Breaking news is unfolding in the immigration world today, and this is not the kind of update anyone can afford to ignore. What has just happened could directly impact you, your family, or someone you know who is currently navigating the U.S. immigration system. A federal judge has issued a court order that blocks certain deportation operations carried out under the Trump administration. And while this does not stop all deportations, it represents a significant legal development with immediate consequences. If you are in removal proceedings, have a pending immigration case, or are supporting a loved one who does, it is absolutely critical that you understand what this ruling means, what it does not mean, and what steps you should be taking right now to protect yourself and your family. In this video, I am going to walk you through this development carefully and clearly, explain the legal background behind it, break down who is affected and who is not, and share practical actions you can take immediately. Whether you are undocumented, a green card holder, someone with a pending application, or a U.S. citizen with immigrant family members, this ruling has real and immediate implications for you. To understand the significance of this decision, we first need to talk about what actually happened. A federal district court judge issued a temporary restraining order that halts certain immigration enforcement operations that were part of a broader directive from the White House. This point is extremely important, so let me be very clear. The judge did not stop all deportations nationwide. There is no blanket ban on immigration enforcement. Instead, the court blocked specific enforcement actions that targeted particular categories of individuals, especially those with pending applications for relief, individuals with ongoing appeals, and people who were detained during operations that plaintiffs argued violated constitutional due process protections. This is a temporary measure, not a final ruling. It is essentially a pause that allows the court time to fully review the legal arguments and evidence before making a more permanent decision. Because this is a temporary restraining order, it is currently in effect, but it is not set in stone. The government has the right to appeal. The order can be modified, and it could be extended or lifted depending on how the case progresses in the coming days and weeks. Immigration litigation moves quickly, and the legal landscape can change almost overnight. That is why staying informed and working closely with a qualified immigration attorney is so important right now. To understand why this court order was issued in the first place, we need to step back and look at what changed in immigration enforcement policy. When the Trump administration took office in January 2025, it signed a series of executive orders that dramatically expanded immigration enforcement priorities. Unlike previous policies that focused enforcement resources primarily on individuals with serious criminal convictions or recent border crossers, the new directives broadened enforcement to include almost anyone in the United States without lawful status. In some cases, this expansion also affected individuals who had pending cases, temporary protections, or applications that had not yet been adjudicated. The administration also increased worksite enforcement, expanded cooperation between local law enforcement and federal immigration authorities, and pushed to accelerate removal proceedings across the board. The result was a sharp rise in arrests, detentions, and deportation efforts. Many individuals found themselves placed into removal proceedings or fast-tracked for deportation, even though they had pending applications, appeals, or strong ties to the United States. Civil rights organizations, immigrant advocacy groups, and several states responded by filing lawsuits challenging these enforcement actions. They argued that the policies violated due process rights, exceeded executive authority, and in some cases unfairly targeted individuals based on national origin or other protected characteristics. The court order we are discussing today is one result of that litigation. According to court filings and preliminary statements, the judge identified several serious concerns. First, the court found that some individuals who were detained or scheduled for removal were not given adequate notice or a meaningful opportunity to present their cases, which raises serious due process concerns under the Fifth Amendment. Second, the court expressed concern that the accelerated pace of enforcement was leading to mistakes, including cases where individuals with valid claims for relief or even lawful status were being caught up in enforcement operations. Third, the plaintiffs presented evidence suggesting that some enforcement actions were being carried out in ways that conflicted with existing regulations and agency guidance, potentially exceeding the administration's legal authority. Based on these concerns, the judge concluded that a temporary halt to certain enforcement operations was necessary while the legal challenges are fully reviewed. This does not mean the court has ruled against the administration on the merits of the case yet. It simply means the judge found the concern serious enough to justify a pause. As of early February 2026, the order remains active, but the situation is fluid and could change quickly. Now, one of the most important questions people are asking is who this order actually protects. This is where misunderstandings can become dangerous, so pay close attention. Based on court documents and reporting from credible outlets such as Reuters, the Associated Press, and the New York Times, the order appears to apply to individuals who fall into specific categories. These include people with pending applications for asylum, adjustment of status, temporary protected status, or other forms of relief who were scheduled for removal before their applications were decided. It also includes individuals who have filed appeals with the Board of Immigration Appeals or federal courts and whose cases are still pending. Additionally, it covers individuals detained in specific enforcement operations named in the lawsuit, particularly where plaintiffs argue the operations were conducted without proper warrants or legal authority. In some cases, the order also applies to individuals with long-standing ties to the United States, such as decades of residence, U.S. citizen family members, or other strong equities that the court believes deserve additional review before removal. However, it is just as important to understand who is not protected by this order. Individuals with final orders of removal issued after full proceedings and exhausted appeals are generally not covered. People with serious criminal convictions involving violent crimes or aggravated felonies are also typically excluded. Individuals apprehended at the border while attempting unlawful entry are usually not protected by this order either. Furthermore, the order does not stop ICE from making arrests or placing people into removal proceedings. What it pauses is the actual physical removal, the deportation itself, for those who fall within the protected categories while the court considers the case. This distinction is critical. If you or someone you love is in immigration proceedings, this order may buy time, but it does not erase the case. It does not grant permanent legal status, and it does not eliminate the need to pursue relief through the proper legal channels. That brings us to what you should be doing right now if you think this ruling might affect you. First and foremost, if you are in removal proceedings or have a pending immigration case, you need to consult with a qualified immigration attorney immediately. Every case is different, and this court order does not apply automatically to everyone. Many nonprofit organizations and legal aid groups offer free or low-cost consultations, and you can find referrals through the American Immigration Lawyers Association or the Executive Office for Immigration Review's list of pro bono providers. Do not rely on social media posts or secondhand information. A lawyer who reviews your case file can explain whether this order affects you and what steps you should take next. If you have a pending application for relief, make sure it is complete, accurate, and up to date. Keep copies of all receipts, notices, and correspondence. Respond promptly to any requests for evidence. If your case is in immigration court, check your hearing dates and attend every single one. Missing a hearing can result in an in absentia removal order, even if a court order exists elsewhere. If you have a final order of removal but believe you may qualify for a motion to reopen or a stay of removal due to changed circumstances or new evidence, now may be the time to explore those options. The current legal environment is creating opportunities for arguments that may not have been viable before, especially for individuals with strong family ties, humanitarian factors, or medical issues. For green card holders and U.S. citizens with undocumented family members, there may be ways to help through family petitions, prosecutorial discretion requests, or stays of removal, but these options require careful legal strategy. Staying informed is also essential. Follow updates from USCIS, ICE, EOIR, and reliable news organizations. Be cautious of misinformation and scams, especially from notarios or unlicensed consultants who promise quick fixes. This ruling also highlights the broader immigration battle playing out in the courts. Immigration enforcement has long been a contested issue, and courts continue to play a critical role in checking executive power. Multiple lawsuits are still moving through the system, challenging worksite raids, expedited removal, asylum restrictions, and other policies. More court orders could come, affecting different groups in different ways. At the same time, it is important to acknowledge the emotional toll this uncertainty takes. Living with the fear of detention or separation from family is incredibly stressful. Community organizations, faith-based groups, and mental health services can provide support, and no one should go through this alone. For those with lawful status, staying informed and supporting immigrant communities makes a real difference. Practical steps like creating a family preparedness plan, knowing your rights, keeping documents organized, and staying connected to reliable information can help protect you during uncertain times. While this court order is significant, it is not a permanent solution. Long term change will require legislative action and comprehensive immigration reform. As of February 5th, 2026, this is where things stand. A federal judge has temporarily blocked certain deportation operations, providing limited relief for some individuals with pending cases, and raising serious legal questions about due process and executive authority. If you are affected, consult an attorney, stay informed, and take proactive steps to protect yourself and your family. This story is still unfolding, and immigration policy continues to evolve. This video is for informational purposes only and does not constitute legal advice. Always rely on official sources and qualified legal professionals for guidance specific to your situation. If you found this video helpful, please like, share, and subscribe so you don't miss future updates. I'm here to keep you informed, prepared, and empowered. Take care of yourself and your loved ones.